defer to the primary and constituent power? What sort of matters are we thinking through? So that, because it's not enough to say, let the courts decide. We must understand as judges, as we sit here today, there are certain matters that you're saying are reserved for us. What matters are those in your thinking? Mr. Dasa and Ms. Kituku, the questions have been asked by my colleagues about Article 250 sub Article 1. But I want to reiterate the question by putting it this way. No provision in a constitution like ours is placed in vain. So that I think in answering my colleagues' questions, tell us as a constitutional question, what is the purpose for 250 sub Article 1? I had arguments that IEBC can do some matters administratively. IEBC can do some matters as a matter of constitutional mandate. Now, explain to me what it can do under 250 sub Article 1 with the minimum of 3. Thank you, Chief Justice.
Thank you. I think we'll follow the practice of giving you 3 minutes to respond.
My Lady the Chief Justice, I have 3 questions. They cannot humanly be answered in 3 minutes. I'll suggest I answer them effectively because they are important to this clarification. My Lord Justice Ouko, you've asked, did the High Court or the Court of Appeal provide with exactitude the location of the basic structure doctrine? The answer is yes. And both the High Court and the Court of Appeal said, for you to identify the basic structure, you must look at the history beneath that particular article. Over and above the history, examine the text. Take, for instance, the judiciary. How did it migrate from the judicature to the judiciary? Because before the judiciary, the judicature was a department of the executive. To that extent, therefore, for you to locate the basic structure, you must confine yourself to those 2 fundamental guiding points. I will give you an example. Nelson Harvey here is male, is a human being. He was born whole. To use the Bible verse in Genesis 1, and God looked at him and said, behold, a perfect being. I can lose a limb. I'll be given an artificial limb to make myself better. I can lose my sight. I'll be given glasses to make my sight better. But if you dismember me negatively by separating the limbs, the lower limbs and the torso, I will die. And if I'm to be succeeded, then I'll have to be replaced by somebody else, perhaps Nelson Harvey II. Essentially, that is the best and simplistic understanding of the basic structure. You will not give me a pig's heart to make me whole. I will live for 1 month and die. So I think to that extent that question is satisfactorily answered. Now, the 4 sequential steps, are they located in the Constitution? No, they are not located in the Constitution. Why are they not located in the Constitution? Let me use myself as the example. I was born. I will die. The manner of my death is not known. Perhaps I will die in my sleep. Perhaps, and to use Professor Githu's words, I will be assassinated. Because in my status, I cannot be murdered, I can only be assassinated. Perhaps I'll die of ailment. So you cannot define with exactitude the manner in which the Constitution will end. Therefore, if you see all these constitutions, the 2010, I believe I'm not being asked to stop. The 2010, the 1969, and the 1963, they do not provide for the amount of air. But when you look at the 2010 Constitution, you will see it repealing the 1969 Constitution. Those 4 sequential steps, you will trace them from the writings of Professor Nubweze. I can categorize them as primordial, as the imperial creation. You cannot find them within the body. Let me give you another example from the Bible. Trace the genealogy of Jesus in the book of Matthew, Luke, or Mark. You will see it sequentially taken back to Joseph, to David, and finally to Abraham and Adam. Beyond Adam, it is the Creator which is outside the being. And it is these basic concepts that must be read into the basic stuff. And if there is a contradiction that may be introduced into this argument, let's go back to the being. There are 2 principles. One, we came into existence by creation. We'll follow the genealogy up to Adam. The other one, we came here by evolution. Whichever avenue you pursue, you must go back behind the being. And that is what we call the primordial power, insofar as the constituent power is concerned. Now, constitutions are peculiar to France and the United States of America. These are the 2 countries that said, will henceforth not be governed by an emperor or the King of England, but will formulate a way in which we'll govern ourselves. We'll set up a constitution with 3 fundamental organs: the executive, the judiciary, and the legislature, so that these functions will not be left to a monarch. Dr. Smokin Wanjala, you've asked, how did the word altar disappear? Was it deliberate? And what do we do about it? It is my answer that the disappearance of the word altar was premeditated and deliberate. And if you look at the writings of Professor Nobweze, he says the fundamental changes to the Independence Constitution were permissible because of a flaw in the definition of the word altar. So that flaw has now been corrected. So that you will not graft an antelope on me and you say you have a being. That is the intention of the framers of the Constitution. And the court ought not to resuscitate it. Because if you do resuscitate it, you will have created the mode of death of a constitution. And that is not what the framers of the Constitution intended. We've gone back to tracing the origin of the constituent power. Does it have a juridical form? The Pharisees asked Jesus, when will we know the end of time? We will never know the end of time, but you will see the signs of the end of time. That is what the teacher said. Now, Aaron Ringera has given clarity to this matter in the case of Njoya versus the Attorney General at page 677. This is what he said. Indeed, it is not expressly textualized by the Constitution. And, of course, it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they will do so only ex abundanti cautela. For instance, I was born here in Kenya. I need not to have an ID or passport, to use the terms of Meguna, for me to be a Kenyan. The ID and passport is there for formality, and it is from that premise that we must perceive the constituent power. Justice Lenaona, You've referred to the Casavananda case, and you've asked us to create a clarity of where these other facets of the basic structure reside outside 255(1)A to J. Now, that is the reason as to why they have to be basic. When we were in Musingu, Ongoya went to study power mechanics, and because I didn't have greater qualification when I joined high school, I studied art and design. But there is a dichotomy between a diesel engine and a petrol engine. There is the carburetor and the injector pump. And if you doubt this difference, if you attempt to kick it like a stone, you will not travel. It is as simple as that. Now, the foundation of a democratic state is based upon the social contract, with the trichotomy of parliament, judiciary, and the executive. And if any of those two are fused, then you are obliterating and obscuring that dichotomy. And I can say affirmatively, from my limited learning of the law, that the basic structure must of necessity include the executive, the judiciary, the legislature, and the Bill of Rights. Because for the Englishmen, they said, "Oh, King, no, you cannot rule us like this. We must have the Magna Carta for us to have terms of engagement." For the French and for the American, they said, we must have a written constitution. And for that, the king will not be the legislative. The king will not be the judiciary, and will have rights that you are not giving us, rights that inhere in us as being. To that extent, therefore, those must be entrenched and respected as the basic structure, which can be discerned outside 255(1)A to J. I believe I've done my part. Or if there's a follow-up question?
Yes, you took your time, 9 minutes.
The time is not of essence here. This is a serious enterprise.
Yes.
The Supreme Court only sits once after 5 years. We did that in an election petition. What is the hurry? Where are we going to?
Yes, thank you.
Good morning, my lady, the Chief Justice, my lady and my lords, justices of the Supreme Court. Your Lordship, your Ladyship, Justice of the Supreme Court, Njoki Ndung'u, you have asked, there are express provisions on quorum for Parliament to conduct business for this court to sit. That's at Article 121 and Article 163(2). There is no express provision for quorum of the IEBC and indeed the other independent commissions that are established under Chapter 18, for the basic reason that the Constitution provides for the Commission's minimum and maximum composition. It does not provide a specific number of composition under the Constitution as it does for this court, which is 7, and it does for Parliament and for Senate, because those are specified in the Constitution. Hence, the ability for the drafters of the Constitution to set the quorum as they intended during the drafting. Now, what is the purpose of the minimum and maximum? And I think that is related to the question that has been asked by His Lordship, Dr. Wanjala, and His Lordship, Justice Isaac Lenola.
How do we sort this thing ya kusema?
Engine,
Nani Maracha?
the two engines that I spoke about, the Constitution and the statute. The Constitution did not specifically provide for the set number of commissioners. It therefore could not provide for the set number in terms of quorum. That is why the Constitution, under 88.5, says that the Commission must operate on the basis of the Constitution and the legislation. And in the legislation, Parliament, in its wisdom, sets the composition as it did, currently at 7, and sets the quorum in the schedule at paragraph 5, whose deletion or repeal or declaration of unconstitutionality is core to the dispute before this court. And I will clarify for my lady, Njoki Ndung'u, Justice of the Supreme Court, that it was not my suggestion, at least not to my recollection, that we need to read quorum into the Constitution. That seems to be the implied suggestion from the submissions of the IEBC, that we should read the minimum of 3 as the implied quorum for the Commission.
We will give you another 3 minutes, but please don't rehearse. We have what you send in the submissions. Just stick to answering the question.
Thank you, my lady. That was the IEBC's submission. Our submission is that you cannot imply quorum based on Article 251, which provides for a minimum of 3. His Lordship, Dr. Wanjala, asked if Parliament, in its wisdom, sets the composition as 3, which is the minimum provided for by the Constitution, and sets quorum at 2. I disagree that it could set quorum at 3, because that would be a unanimous decision, and quorum is the minimum number required to make a binding decision. Would that be bad law? If Parliament, in its wisdom, did that, went through the legislative process, gave an opportunity for public participation, had the views, and did that, and no one challenged that constitution of 3 in a court of law, and there is no decision of the court that finds it to be unconstitutional, then it would stand as good law. But as we speak, the section that provides for the constitution of the Commission has not been changed. So quorum cannot be a minority of that set composition. And I would like to end there and bring to this court the current situation. If you were to take the submissions of the IEBC and confirm or put it as the position in law that the quorum can be 3 because the composition can be 3 as set as a minimum in the Constitution, what you will be saying is that the Commission, as currently composed by statute, would be bound by a decision of the minimum membership. But what is most important, my ladies and my lords, is that alongside the declaration of unconstitutionality of paragraph 5 of the schedule was a declaration of unconstitutionality of paragraph 7 of the schedule, which said that where a unanimous decision is not reached, then the decision of the majority of the members present and sitting would hold as a decision of the Commission. As it is now, therefore, there is a lacuna, if you were to take the arguments of the Commission, in the law on that question, so that we are going to a point where 3 commissioners will say, our decision can bind the Commission, whereas on the other hand, 4 commissioners would say, we are the majority, our decision ought to bind the Commission. That is the risk that we are at, because the flight went so far away from the flight path with 1 engine and passengers inside it. Do not forget that. I urge this court not to forget that. We will have that situation, and I do not think it is in the realm of imagination, where 3 commissioners will say, we stand, and 4 say, we stand. Thank you.
The Honorable, the Chief Justice, my ladies, my lords, my name is Justice Njiru Nyaga, third appellant. And for the sake of clarity, Justice is my name, not my title. I will be addressing the questions that have been raised by the Honorable Judges, starting with the question of Lenaola J as to the purpose of Article 250, sub-article 1, concerning the minimum of 3. Can IEBC do some matters administratively? And the simple answer to that is no. And we wish to seek solace from the decision of the High Court in this matter, where they were explicit that the statute which has been implemented by, has been enacted pursuant to Article 88(5), does not make a distinction between administrative and policy issues. And that is a point of departure from the decision of Biwott, where the Biwott case was saying it is policy issues only. But the High Court distinguished that, and they said that is bad law, and they respectfully departed from that. So our straight answer to that is no. As per the law, they cannot even do administrative issues. To the question by Lady Justice Njoki, what is the purpose of Article 251? In essence, it just defines the composition, the minimum number of members who can compose an independent commission, because it is trite that there is safety in a multitude of councillors. And when you look at the Biwott case, the issue of quorum came up, and it was clearly defined that quorum is the minimum number that is required for a commissioner, for a commission to transact its business. So 251 states the minimum membership, but the legislation that has been enacted, that is the second schedule to the IEBC Act, clearly provides for the minimum number of commissioners to transact business, and that is 5. And we still hold that the High Court and the Court of Appeal were right in finding that that provision is still valid. Let me go quickly to the next question, and we will be pleading with the Honorable Chief Justice that for Topua's question, he can be granted his time to address it, the question on basic structure that has been raised by Honorable Lenaola J. Judge of the Supreme Court. To the question of Justice Smokin Wanjala, if membership is set at 3, and I will be requesting for just a few more minutes so that I also address Oko's, Justice Oko's question. May I proceed? Thank you. Concerning the question by Justice Smokin Wanjala, if membership is set at 3 and the quorum at 3 or is set at 3 or 2, is that bad law? We respectfully submit that that will be bad law, having in mind the important functions that the IBC conducts. And when you look at the letter and the spirit of the Constitution, it will be wrong to have important decisions of great magnitude being transacted by only 2 commissioners. So for that, we will humbly respectfully submit that that will be bad law. Concerning the last question by Honorable Justice Oko, what is the status of the actions that were taken when the IEBC was not queried? We respectfully submit first that what is before this court is not the matters that were taken by IEBC such as even the composition of the court, or the by-elections. But what is before this honorable court is a question of the amendment of the Constitution. However, that being said, we take solace in the decision of this honorable court in the case of Mary Wamboi Munene versus Peter Gishuki Kingara and two others, a 2014 decision, where you are very clear as to the effect of a provision of a statute being declared unconstitutional. It can either be retrospective or prospective. Therefore, in this case, for matters which the court will look at and see that this, if we are to apply them retrospectively, they might have serious implications, the court can respectfully decide to have them be prospective. And therefore, we humbly submit that you do not buy into the suggestion that has been given by the Honorable, the former Attorney General, Professor Muigai, who I greatly respect, that in any such case, the default position ought to be the application is retrospective. And that is what the decision, that was your decision in the case of Mary Wamboi. And allow me just to finish with what Justice Kriegler said. And this is what he mentioned. I'll read quickly in that decision, which this court rightly quoted. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado. Though it's sometimes convenient to have the court to declare it to be so, and every proceeding which is founded on it is also bad and incurably bad. You cannot put something on it and expect it to stay. It will collapse. The default position concerning this matter is that the declaration of an unconstitutional amendment to a statute should be retrospective. And for that reason, paragraph 5 and paragraph 7 of the IBC Act, second schedule, still apply.
Thank you. Don't rehearse. Yes, we have taken the answer. Ms. Kituku.
I will invite now Mr. Tokua.
Thank you, Chief Justice. I will start with the question asked by the Honorable Justice Ouko on what would happen to the actions that have already been undertaken by the IBC when it was not queried. To answer that question, I would suggest and say that the powers of a court to issue a remedy upon a declaration are very varied. A court can suspend the applicability of the unconstitutional invalidity either retrospectively or prospectively. When it does apply it retrospective, it saves those acts that have already been done. When it applies it prospectively, it does cure the gap that would happen between the date of the declaration and the date that Parliament would be ordinarily remedy the invalidity. Therefore, in this case, we would suggest on the first aspect to say, number one, that either we apply it retrospectively or prospectively. The actions on Article 257.45 were done after the judgment in the Katiba Institute. So it will not have any effect on this. It will not change the status of that declaration. However, if there was no order that was issued suspending the declaration, a party that is aggrieved by that, If no order of suspension is issued, it means that the declaration, although issued in rem, cannot apply to each and every action that IBC did. A party aggrieved by a particular action that IBC did during that period it was not queried must move the court in order to have that declaration applied in that action that that party is aggrieved with. For example, if a party was aggrieved, on the result of the elections of the president of the Court of Appeal, that party must move the court and have that declaration apply in that case. So I refer the court to maybe the example in the Murwatetu case, when this court issued a declaration that the death penalty was unconstitutional. It did not mean that every convict who was on the death law was set free. However, that the lower court or any other judge who sought to apply that reasoning in the Murwatetu case had to bring it within the confines of the case that was before them. So it does not entirely apply bracketry, but it has to be brought within the ambit. My lady Chief Justice, I think I'll be seeking more time. I have 5 more questions to answer for the members of the bench.
Yes, if you can summarize them to answers, please don't rehearse your submission because we have it. Just zero in on the answer.
Thank you, Madam Chief Justice.
So we are giving you another 3 minutes.
On the issue of public participation, as was asked by the Chief Justice and Honorable Justice Njoki Ndung'u, I will start by saying public participation is a factual issue. It can only be determined by evidence, whether or not there was public participation. The issue was specifically pleaded in the Third Way Alliance case that there was no public participation. None of the parties in the matter brought any evidence to prove whether there was public participation. In the absence of such evidence, then the court did find that there was no public participation. Although the counties had been sued and processed the bill without public participation, did not participate in the proceedings. So therefore, the obvious conclusion would be, in the absence of any evidence, there was no public participation. The issue of public participation was actually not contested. The IBC did not provide any evidence on the issue that was raised by public participation in the pleadings, in the Superior Court. On the question by the Chief Justice, how should this public participation look like? Ideally, it would be left to the IBC to determine how best to undertake public participation in line with the law and the regulations that exist. Its own procedures, administrative procedures, provided how IBC would undertake public participation in relation to verification and certification in relation to signatures and Article 257 form. There are many methods that IBC could have done that. At a minimum, it ought to have perhaps provided the list of the supporters to the popular initiative at every polling station for inspection so that members can have an opportunity to engage with the list. Number 2, it could have also used other media services that are easily available to the members of the public. It could have used print media, all television, the radio station, TV, just to popularize that list. And also, it could have done what the Elections Act says, that's what I've said, through physical inspection of the register. On the question again by Justice Njoki Ndung'u, Justice Wanjala, and Justice Lenaola, on the quorum, on why Article 251 and its importance, I will start by saying that we can't find that answer in the CKLC report. The CKLC on the Constitution, there were concerns that sometimes the commissions could have been too big or they could have been too small. So the idea was to restrict the number of the commissioners. And number 2, Chief Justice, I humbly request for 1 minute to wind up. Thank you. To restrict the number or provide Parliament with the leeway to set the appropriate number of members as commissions are different and carry out different constitutional obligations. For example, the Kenya National Human Rights Commission has 5 members set by registration. The National Gender and Equality Commission has 5. The Judicial Service Commission has 11 members. So this is an issue that was left to the Parliament to determine the number of commissioners. So therefore, in Parliament, in its wisdom, which Parliament does not legislate in a vacuum, but Parliament understands and knows the needs of its people, understands its history. When it did set the number of the IBC commissioners as a minimum of 5 and a maximum of 7, it clearly undertook its mandate and understood what it was doing. So that registration that put the number as 5 has not been challenged in this court. It is not on appeal, and we urge the court to find as such. I will associate myself with the submissions made by Mr. Nyaga on the issue of business and policy of the IBC. Thank you.
Thank you, my lady, my lords. Direct the questions. Am I suggesting that this court is bound by the rule of limiting itself to matters of law in case of a second appeal? Yes, that's what I'm submitting, for the following reasons. Article 163 that gives that right of direct appeal, it's a direct of appeal where what is at issue is interpretation or application of the Constitution. In doing that, you employ Article 259 of the Constitution, which provides legal principles. Section 3 of the Act establishing this court, which sets out legal principles. So the matters that we are doing are actually application of legal principles to the question at hand, and not an investigation of the facts afresh. Secondly, the case of Munya, which you engaged with this question a little, you found that a second appeal in an election matter can be preferred to this court because it involves an interpretation and application of the Constitution, but that is limited to questions of law. So I wish I had more time to do further research, but bottom line is, based on that, I'm convinced that we are limited by that rule. Just a brief engagement with the question of the quorum, because I have a bit of time there. It's important to understand the scheme of Article 251. Minimum 3, maximum 9. It's not arbitrary, it's not magical. Parliament cannot just pick 3. It has to engage with the many other factors you find in Article 232 of the Constitution, Article 10 on regional balancing, on gender balancing. So if it just arbitrarily picked a number, then that number can be challenged because of the rule of harmonious reading of the Constitution. Fortunately for us, Parliament in the IEBC case did not pick 3. So to that extent, again, the question of the IEBC must be determined in full light of the numbers that Parliament in fact picked and the statutory arrangements that there were regarding the question of the quorum of the IEBC. My assistant, Mr. Ogada, desires to make some contribution, my Lady Chief Justice. I'll kindly invite you to, I'll request you to allow him to make a measure of contribution to one of the questions that we thought could have been dealt with better.
We'll give him 3 minutes.
Fair enough.
Thank you, Your Ladyship. The question of public participation, your question was precise. In the absence of legal framework, does the Constitution provide for how to deal with public participation? Article 259, Your Ladyship, Chief Justice, 259.1. Conceptually, that's purposive interpretation. 259.3. A non-living tree reading of the Constitution, originally from the case of Edward versus Sankey, Canadian case. Read that together with Article 165.3, which gives original primacy to the High Court, sitting as the Constitutional Court, to interpret the law. What am I saying? The court, the judiciary, has the unique role to give meaning to the abstract provisions of the Constitution, such that when Justice Odunga sits and in expert Egekuru says that these are the parameters, these are the conceptual contours of public participation, the court has exercised its mandate under the Constitution. Quickly, on the question of when does Commonwealth law and international law become part for purposes of persuasion, our law. Article 2.5 speaks of general rules of international law. Conceptually, that is wrong. It should be general principles of international law. Justice Dr. Wanjala, you have taught international law before. You will bear me witness. Article 38(1), where we get the sources of international law, speaks of general principles of international law. So as a subsidiary source of international law, we will look at the preponderance of decisions from around the world. And when these courts identify certain principles, certain doctrines to be applied robustly or uniformly around the world, then you will be persuaded that humanity has found these principles to apply commonly, and we will adopt them. That's my submission. Thank you.
You have the floor, Dr. Kamini.
Yeah, can I speak, my lady? Thank you. My lady, I have understood your question, but with respect, we are dealing with a specific case, Casavananda case. And it's my humble submission that this case, Casavananda, is taken care of by Article 38 of the Statute of the International Court of Justice, Statute of International Court of Justice, which specifically refers to cases decided by national courts. And there is, this is referred to in page 41 of Brownlee's Principles of Public International Law, 8th edition, where he says very briefly, when I read the sentence, Article 38, 1D of the Statute of International Court is not limited to international decisions. Decisions of national courts also have value. Decisions of national courts also have value. And specifically the question is answered, which you have raised in the little book written by, the title is Unconstitutional Constitutional Amendments. Constitutional amendments by Yaniv Rosnai, pages 47 to 70. The basic structure has spread in Asia from India to Bangladesh, to Pakistan, to South Korea, Japan, China, Taiwan, Thailand, Sri Lanka, Malaysia, and Singapore, and in Africa to Kenya, South Africa, Tanzania, and Uganda, although Uganda is not mentioned, but Uganda we have a case there, and then Central and South America, Caribbean, and it's my humble submission that this case or this decision has what we call the qualities of jurisprudence. Thank you, my lady. I urge you again respectfully throughout this Bbi appeal. Let us forget about it and move on to something else in life.
Thank you. Thank you.
My Lord, the Chief Justice, the Deputy Chief Justice, Justices of the Supreme Court, my name is Topwale Sinko, and I'm here to respond to Justice Isaac Lenaola's question on Article 368 of the Indian Constitution, as read together with the Casavananda case, and as I understood, his argument was that Article 368 of the Indian Constitution gives Parliament almost what I can call unlimited powers in amending the Constitution. Let me first say that my import and my argument with regard to the Kesavananda case was in relation to the Attorney General argument that the High Court and the Court of Appeal erred in relying on that case, which actually is restricted on parliamentary amendment of the Constitution, is distinguished to the Kenyan current case, which was actually the issue of the referendum by the popular initiative. Let me go back. Just in India, the Golaknath case was the state of Punjab. I think it's a 1967 case. It was first held by the Supreme Court that some of the sections of the Indian Constitution, including fundamental rights, could not be altered. And coming back forward to the Kesavananda case, we have the majority decision read by Chief Justice Sikri saying that Parliament could not use its amending powers to alter or damage the Constitution. That leaves us in a situation where, despite the Constitution really giving unlimited powers to Parliament to amend, the Supreme Court, by all its rights, tends to limit. I think, and this despite references under Article 368 that seeks to host judicial review. So it was my argument then before this court that the Kesavananda case may not actually be relevant so much to the current appeal under consideration, on the ground that my reading of the High Court decision and the Court of Appeal, the judges were clear, I think under paragraph 472 Superior Court and the Majority Court of Appeal, that the Constitution of Kenya is amendable. No immutable clauses, no eternity clauses, and therefore the argument by the Attorney General cannot stand on that issue because ours is amendable, unlike the Indian Constitution based on the holding in Kesavananda that Parliament cannot alter some of what is regarded as fundamental under the Indian Constitution. In that regard, it was my argument that the appeal then fails in trying to impute the High Court and the Court of Appeal decision on our reliance to the Kesavananda case, which I think it's not really relevant. Thank you.
Thank you for those responses. We will now give time to the first appellant, the second and the third appellant to respond.
May I say something, my lady? My lady, can you permit me to say something?
Yes, Dr. Camino.
Yeah. My lady, I have an idea of the extent of the Supreme Court library and even the Court of Appeal library. Now, I have a number of books on this amendability, and I would be prepared to hand them to your registrar should any of the members of the court wish to have them. I have a book called Making Constitutions in Deeply Divided Societies. I have another one called An Amendable Constitution. I have another one called Unconstitutional Constitutional Amendments. I have another one called Constitutional Amendments. I have another one called Responding to Imperfection, the Theory and Practice of a Constitutional Amendment. I have another one called 6 Amendments, How and Why We Should Change the Constitution. I have another one called The Foundations and Traditions of Constitutional Amendment.
Thank you for the donation.
I'm prepared to hand them to the court. Should it be necessary, the registrar can get in touch with me.
Yes, we will borrow them to use and then return to you because we don't want to deplete your library. Subsequently, we will order our own copies if we don't have them in our library.
Your Ladyship, the Chief Justice, the legal team for the second appellant had requested that they do their response first, and the reason that they had requested was that so that whatever time they do not utilize for their response, subject, of course, to the court's convenience, they have kindly agreed to donate to us.
My Lord the Chief Justice, my Lord the Deputy Chief Justice, and my Lords the Justices of Supreme Court, good afternoon. My name is Justice Munyithia for record. Happy to be before you. My Lord, I was last year in 2017 on an election petition, and this will be my maiden appearance before you since you were elevated to the office. My Lord, you had given us 25 minutes, and we had 5 minutes left. I'll take 5 minutes to respond to Morara's question, and my colleagues will respond to the other issues. My Lord, this question was raised by Justice Lanola yesterday, and my lead counsel, Professor Gedu, answered that the answer would be found in the decision of 208J as to whether the question of framing the referendum question was right. We have filed responses to that issue in that, and we have also put our written submissions. I will therefore highlight and say that we oppose that question with only one ground, that this issue was not live for determination. In doing so, my Lord, we realized that there was a definite finding by the High Court, and the Court of Appeal overturned or set that decision on page 8360 of the Record of Appeal. Why do we say that this matter was not ripe for determination? Lord, the only law that we have that governs the referendum in the statute books is the Elections Act. Section 49, Section 50, and Section 51. It is very clear that whenever questions of referendum arise, whenever those questions arise, there is step that must be taken. Now, there is no doubt, and Morara has not responded to this, that the process was stopped when it was still in the National Assembly and some of the county assemblies. It had not moved to the President, who, once he receives the bill, will now forward it back to the IBC to frame the question. So that when we were in the High Court and the Court of Appeal, that question was not ripe for determination. This court and many other times, we have had judicial interpretation that the only time a court is says of jurisdiction to interpret a matter is when that matter is in dispute and you don't adjudicate on matters that are likely to happen in the future. So that in raising that issue, or the High Court in trying to determine on that issue, there was speculating in the future what happens. Two, the commission under Article 248, it's one of the independent commission. Under Article 249, it is not subject to control of any authority. We don't doubt that courts can intervene. But when the High Court is exercising its jurisdiction, one, it cannot exercise jurisdiction that is reserved of the Supreme Court. That is very clear in Article 165(5). Two, even if there was need to seek that supervisory opinion for purposes of that advisory opinion, then the matter can only be referred to by IVC in the Supreme Court on the question of framing. So that when High Court pronounces itself, it would amount, one, entering into the mandate of the IBC in terms of framing the question, and that is rightly pointed out by Justice Toyot. Two, it will be exercising advisory opinion. Now, the other issue that I want to address is, can this court now interfere with the decision of the Court of Appeal as far as this matter is concerned? My Lord, like we put, this court now is exercising appellate jurisdiction under Article 1634, and therefore it can only address the question raised. It cannot reserve or become an advisory or give an advisory opinion. So we submit that the questions that came before the court by the High Court itself, it was wrong because it offended the doctrine of ripeness. The Court of Appeal was right in setting aside that other point. My Lord, you cannot start counting your chicken until they hatch. This is exactly what the High Court was doing. We urge you not to be tempted to move to that. We urge that you uphold the decision by the Court of Appeal on this issue. Thank you very much. I'll invite my colleague.
Good afternoon, my ladies and my lords. In a very quick rejoinder in relation to the question of public participation, I would want to draw, with your permission, the provision, the attention of this court, the provisions of Article 257, Subarticle 4. Reads, my ladies and my lords, that the promoters of a popular initiative shall deliver the draft bill and the supporting signatures to the Independent Electoral and Boundaries Commission, which shall verify that the initiative is supported by at least 1 million registered voters. My ladies and my lords, the reason I draw your attention to that provision is because our appeal is limited to that particular provision. And specifically, the IBC did file an appeal in relation to a very targeted question, a question arising from the finding of the High Court, that the IBC, in applying or interpreting the provisions of Article 257.4, is also called upon to confirm that the promoters of the initiative have conducted public participation. That was the first finding, and we did make reference to paragraph 577 of a decision of the High Court. Again, the second limb of our argument was whether the Court of Appeal was right in interpreting that Article 257.4 to mean that the IBC should have actually been the one to conduct public participation. My lords and my ladies, our position then, as it is now, is that a true reading of that particular provision cannot time. So that under Article 257.4, there is no time prescribed for it to be able to then forward the bill and the signatures to the county assembly. My ladies and my lords, that, in my very humble view, would be a slanted reading of that particular provision. The second reason they give is that IBC is ordinarily expected to have money. Again, my ladies and my lords, that cannot be the reason we say that that obligation crystallizes on the IBC. It is our submission, my lords and my ladies, that if, like I said yesterday and the day before, the process of constitutional review under Article 257 is incremental, and that it establishes several areas where public participation is to be done. And on this, I got support from my learned friend appearing for Muhuri, that is Council Christine. My ladies and my lords, she agrees with me that Article 196 speaks to how then the county assemblies are supposed to achieve public participation. That is a very important concession. Again, we made submissions and no one has contested it, that Article 94 and 95 provides for how public participation can be achieved. So, my ladies and my lords, that remains our submission, that a true reading of that Article 257.4 cannot yield the two meanings assigned to it by both the High Court and the Court of Appeal. My ladies and my lords, that said, I've also had submission, again from the respondents, which appear in one way or the other to want to expand the scope of our appeal. Our appeal did not touch on the question of verification of signatures. I've had lengthy submissions on that question. Please, my ladies and my lords, it is our submission that that component of repeal should be disregarded because it does not flow from our repeal. Again, I've had submissions to the effect that the finding that there was no adequate legal framework is an issue that touches on public participation. With respect, my ladies and my lords, that does not flow from our appeal. That said, yesterday I did draw the attention of the court to your locus classicus, the decision in BAT by the CS Health. One of the principles under paragraph 96 of that decision is that every case where public participation is called, and that was this court applying the meaning of public participation that should be ascribed to Article 10, Subarticle 2, that at principle number 8, you say that each case is supposed to be looked at with the peculiarity of the circumstances in issue. It then follows that following that principle, one then does not read public participation in every article of the Constitution. And I'll give two examples. My ladies and my lords, today you sit to interpret and give meaning to this Constitution. That is what we have all come before you to do. Now, in the ordinary parlance of the Constitution, one would be tempted to apply the provisions of Article 10, Subarticle 2 in relation to public participation. Would it not be turning logic onto its head to say that then, as you retire to do your judgment on this matter, then we call for public participation? I think that would be stretching the meaning of that particular provision. Second example, the AG, I think under Article 156, is the principal advisor to the government on matters law. Again, when the AG prefers an opinion to, say, His Excellency the President, one would not expect that the AG, in conferring that opinion, must then apply public participation. It is our submission, my ladies and my lords, that is the principle that you provided for under principle number 8 of your decision and authority in BAT versus CS Health. And that being the basis, I would also then want to submit, my ladies and my lords, you don't need all legal or statutory framework in relation to that question. My lords, I think that then would respond to the question of public participation, and permit me then to invite my lead counsel, Professor Githu Muigai, to respond to the question of the effect of constitutionality. I'm most obliged.
My Lady Chief Justice, judges of the Supreme Court, I'll be very brief in responding to three main issues. Issue number one is the issue of quorum. It would appear that there is a confusion as to the significance of this matter, which I think needs to be clarified. One group seems to argue the issue of quorum as if it has no consequence, as if a finding of no quorum has no consequence whatsoever, as if it were an academic matter. I think Mr. Justice Ouko, in one of his questions to us, sought to draw out that question of, is there consequence? We have had elections, 50 by-elections. We have had elections of the judge of the president of the Court of Appeal, elections of the justice, JSC's judges' representatives, and so on and so forth. This issue of quorum is not academic. It has consequences. Part of what was sought in the lower court was to find that part of the preparatory process leading to the election we expect in August, in a few months' time, was null and void for lack of quorum. So I want to suggest with the greatest possible respect that your lordships step back, take a deep breath, and worry a little bit about consequence. Number two, a question was raised again by the learned Mr. Justice Ouko. Is there there some silence on the part of IEBC as regards the proposals to create constituencies and the compromise that may have on the IEBC's vested mandate? There is no silence. We are not embarrassed at all. We are only saying we appreciate that the Constitution is not cast in stone. Today we have a power. That power is well clarified. And it is a power to be exercised over a long period. But we have a constitutional moment in which the promoters of this bill feel requires a special intervention. That is not unconstitutional. And I'll give you an example, my lords. When we were involved in the post-2000 2008 problem, the Kofi Annan peace process.